Senator Servo? Here. Senator Edwards? Here. Senator Peterson? Here. Yes, sir.
Okay, I call this meeting to order, and first activity, we take up the bills.
Delegate Scott, whenever you're ready, please go ahead.
Good morning, Mr. Chair and members of the committee. Thank you for having me. I'm presenting House Bill 2055. It's basically a bill that's an administration bill that's required to comply with the federal child support regulation mandating that states no longer treat incarceration as quote unquote voluntary unemployment for the purposes of determining ability to pay when establishing or modifying a child support order. Failure to comply with the regulations would result in a loss of $74 million in federal funding, which constitutes 66% of total funding for Virginia's child support program. In addition, there will possibly be additional cuts in TANF payments to Virginia residents. Approximately 300,000 families rely on Virginia's Division of Child Support Enforcement, which collects $650 million for families annually. This regulation only affects about 0.9% of total cases of Department of Child Support Enforcement's cases. They have 281,000 plus total cases. This only affects 2,551 of those cases. So I would be asking the committee to support the bill and report the bill forward. I don't understand. There's a very small amount of cases that this would affect, but it would have a large impact on our overall budget if we don't implement this rule. So implement this legislation. So I hope that it be the will of the committee to report the bill, and I entertain any questions you may have. And I think I have two members of staff, Barbara Lucina and the attorney for the Division of Child Support, on standby to answer any questions as well.
Mr. Chairman. Thank you, Mr. Chairman. Good morning, Delegate Scott. Mr. Chairman, I serve on the Child Support Guidelines Work Group on behalf of the Senate, and this topic was taken up by the Child Support Guidelines Work Group over the summer. I serve with Delegate Scott on there also, and my understanding is this change is required by federal regulation, which was actually adopted by the Obama administration. And I believe we also have an additional year to get this adopted. I had originally thought the work group was going to keep considering this over the next 12 months and not push for legislative change this session, but I guess the Department of Child Support Enforcement decided to push it forward, although their recollection of the meeting is a little different than mine. But anyways, having said that, my concern about this change is the vast majority of people that this affects are people who are incarcerated, who don't have any income, and this, when they're in jail, this digs them a big hole to get out. But I also know that at least many of the clients that I tend to represent tend to be higher income, and this law that requires a court to impute income when you're incarcerated has been the law of the Commonwealth since about, I think, 1978, in a case called Edwards v. Lowry, and the Family Law Coalition is very concerned about this change. And I had some clarifying language I wanted to offer to make it clear that this new exception would only apply in the event of incarceration and not conviction. And so the amendment that I wanted to offer is after the word "a party's current incarceration," I want to add the word "alone," and then at the end of the sentence, I wanted to add, and I've emailed this to Kristen, but I emailed it to her too late for her to type it up.
Mr. Chair.
Yeah. finish my
Can you,
amendment.
Hold on one
Mr.
second,
Chair,
delegate.
can the senator refer us to the line in the bill? I'm looking at it, trying to,
I think that's line 43. It would be after current incarceration alone. Is that correct, Delegate, or Senator Servo?
Yeah, that's correct.
Okay, then
okay,
comma.
thank you. Mhm.
And at the
What's
very
the
end
other one?
at the very end of the sentence, also add, provided that nothing herein shall be deemed to prohibit a court from imputing income based on a conviction without incarceration. Any other factor under this section or factors upon release, such as a non-custodial parent's assets, residence, employment, earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the non-custodial parent, prevailing earnings level in the local community, and other relevant background factors in the case. And just so you all don't think I'm inventing words, that actually comes from the federal regulation. And I wanted to make sure that we were in compliance with the federal regulation that's requiring us to do this. But basically, the amendment just makes clear that the only piece of Virginia existing law we're changing is imputation upon actual incarceration, and we're not changing the law that would say that if somebody gets convicted of something and they lose their job, say a 6-figure, or I've seen 7-figure people lose their jobs over conviction, we're not giving them some benefit, trying to help, I think, these deserving people in prison who deserve the help that this regulation is intended to help, and that'd be my motion.
All right, well, hold on one second. Before we adopt that amendment, I'm just reading the statute 20-108.1, and this is just talking about factors. It's not, it doesn't mean, for example, if somebody's a millionaire and they're incarcerated, they may not get relieved of child support. I think it's just, these are just factors, correct?
Is that a question to me, Mr. Chairman?
Question to you.
Mr. Chairman, the way it works is these are grounds that a court can deviate from the presumptive child support guideline. And so if typically what happens is if somebody's incarcerated, the court has to make a finding as to what their actual income is, and then the court is allowed to deviate and make a determination, well, that maybe they don't have any income, but at the time they were incarcerated, they were making $25,000, $30,000, $50,000 a year, and under Virginia law, they are required to assume they're making $50,000 under Factor 3 because their unemployment is deemed willful because it was based on their conviction of a crime and incarceration. So that's sort of how the law works in this.
Okay, all right. Anybody else have questions for Senator Servell? Delegate Stott, did you understand his amendment?
Yeah, I understand his amendment. I'd like to, before we move forward on it, I'd like to see what the Division of Child Support Enforcement has to say on that issue, because what I don't want to do is hinder the underlying issue the problem that we're trying to solve. And I know Senator Servell knows this as well. That's rare. As you said, Mr. Chair, this is just one of the factors. People don't normally, folks don't get modifications if they're rich. I mean, all of those factors and ability to pay are still taken into account in spite of any incarceration. If any assets that they have, any stocks, bonds, all of that's laid out in the list of assets. So the fact that they lose income only probably would not lower their child support obligation if they still have those resources. But I want to listen to what the child support enforcement folks say before we accept the amendment.
Who do we have from Division of Child Support Enforcement? And you have to begin by saying, for the Servell amendment, either love it or hate it, and then explain.
We have Barbara Lucina here first, I think.
Okay, love it or hate it, then explain.
Good morning, Chairman Peterson and members of the subcommittee. Barbara Lucina for the Department of Social Services in the role of Director of the Division of Child Support Enforcement. There are already 14 factors for deviation available to judges in setting or modifying child support amounts. And the ability to pay, as Delegate Scott has explained, is only inclusive of income as one factor. So ability to pay does include already assets and other income that is not related to employment, which of course is limited when a person is incarcerated.
So my question was, for the Servell amendment, love it or hate it?
The department can live with the amendment.
Okay, that was not what I wanted. All right. Scott, can you just report that amendment? Because I usually defer to you on domestic matters, but I'm
Sure.
just wondering if it's necessary, because I kind of have the same instinct as Delegate Scott. This is just a factor. Why do we need to micromanage this?
Mr. Chairman, first of all, I can read it again, but the reason that the amendment is important is because I think in the absence of the language, a lot of judges will assume that we've changed the law. The case called Edwards v. Lowry, which has to do with voluntary underemployment due to conviction. And I wanted to make it crystal clear that we're only dealing with parents who are in jail and not parents who are convicted and not in jail. And so what the amendment would say, Mr. Chairman, is again, after a party's current incarceration, add the word alone.
Right.
And then add to the end, provided that nothing herein shall be deemed to prohibit a court from imputing income based on a conviction without incarceration, any other factor under this section or factors upon release, such as, and this comes from the federal regulations, which is not in the Code of Virginia, a parent's assets, residence, employment, earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as the local job market, availability of employers willing to hire the non-custodial parent, prevailing earnings level in local community, and other relevant factors in this case. And Mr. Chairman, those words are not anywhere in Virginia law, and the federal government is making us do this. We would not be having this bill in front of us today, but for the fact the federal government is ordering us to change our rules.
Okay.
There-
All right, Scott, are you making a motion?
So move.
Second from Edwards to adopt the Cerebell amendment. Staff, do we have that?
And I believe the Family Law Coalition supports the amendment as well, if they're on the line.
Is Family Law Coalition out there? Well, let me ask this. Are there any other witnesses to this bill other than Department
I'd
of
like,
Child-
I think the attorney for child support enforcement is on board. I think she may have a word as well.
Okay. I see Daniel Gray in the room. Daniel,
That's him, yeah.
you want to speak?
Yes, Mr. Chairman.
Yeah, go ahead.
Thank you very much. Yes, if you're Dan Gray on behalf of the Virginia Family Law Coalition, as I think Senator Cerebell knows, we adamantly oppose this bill. However, having said that, I think that Senator Cerebell's amendments are well taken because there is a nuance that, people can be convicted of a crime and not be incarcerated, and we don't want them to be able to use the fact of conviction to say, oh, well, I lost my job because of that, and therefore you shouldn't impute income to me. So Senator Cerebell's amendment dealing only with incarceration, I think is a good change to make to the bill, as well as the language that he's added at the end. But, the coalition still remains adamantly opposed to HB 2055 just on policy grounds, because it shifts the burden of incarceration to primarily women and also children, the recipients of the support, rather than keeping the responsibility on the person who was the wrongdoer. And we are fully aware of the federal implications, the monetary implications, but we can't, on principle, support this change to Virginia law. And Edwards v. Lowry, as Senator Cerebell has said. I'll take any questions, but I appreciate the opportunity to speak to the committee, to the subcommittee.
You love the amendment, but you hate the bill.
That's well said. Yes,
Got it.
Mr. Chairman.
I understand that. Anybody else that are witnesses that want to testify on this bill? And I think Senator Cerebell's bill goes to the whole substance of it. So are there any other witnesses that want to testify regarding either the bill or his amendment?
Valerie LaFaro, please go ahead.
Yes, thank you. Valerie LaRue from Virginia Poverty Law Center. And I will say that we were initially opposed to this bill, just like the Family Law Coalition was. And one of the reasons we were opposed was because we were concerned about incarceration and conviction, both serving to sort of flip that switch on the issue of voluntary unemployment or underemployment. But after looking at it more closely, I realized, this doesn't say that if you're just convicted of a crime that you're now no longer, voluntarily unemployed. It's only incarceration. So I think that Senator Cerebell's amendment probably will clear that up for a lot of people. one of the things that I think is important to note is that people can be convicted of the same crime, but only some people will be incarcerated for that crime. And so I think this has an important racial justice component because all people who are convicted will still be treated the same. And people who are incarcerated have to affirmatively seek out a reduction. It's not going to wipe out their arrearage. They have to affirmatively seek out a reduction in their child support. The judge has to review that. So although initially I was opposed to it, now I see that this will actually, I think, put people on a more equal footing, whether they're incarcerated or not, just based on the fact of their conviction and not having anything to do with their incarceration. So we have come around from being opposed to this bill to actually supporting this bill. People will not be in such a big hole when they come out of incarceration.
We got it. All right.
Great.
So you went from hating it to loving it.
Yes, exactly.
Great. All right. Any other witnesses?
Lauren Steele, please unmute and go ahead.
Good morning, Chairman Peterson and the committee. Can everybody hear me okay?
Yes, sir.
Thank you. I'm Lawrence Deal, lawyer with the firm of Barnes & Deal. I practiced family law for 46 years, co-author of our leading treatise, and my chapter is on child support. And I've written many of our statutes and appeared before the committee on testifying on these things. I am adamantly opposed, and the coalition is opposed, but let me give you some more details as to why and a solution at the end. Our policy for years has been to impute income for wrongdoing, whether that's voluntarily reducing your income by changing your job or maybe not getting along with your supervisor. But clearly our case law, Senator Servo said, does not reward incarcerated people, parents, to the detriment of the innocent parent. This whole federal thing is focusing on, the poor innocent, the poor convicted person, children. That should be the best interest that we've always had as our policy. This turns it on its head. And let me give you a real world impact of what this statute could do. And this really affects more low-income people. The high-income people, as said, is not the problem. They're not going to have it reduced, most likely, or even try. But the people that are struggling to raise their children who are innocent, let's just take hypothetically that there's 2 children. The total support is $700, $300 for the custodial parent that's innocent, $400 for the non-custodial parent who's convicted. For 3 years, that person's in jail. That would be a $14,400 arrearage. Now, the feds will say, well, if we don't have that arrearage, they will pay that back more. And I'm going to address the survey that is in the federal regs, which I may be one of the few people that's actually read it and studied it because it's flawed completely. That person, after 3 years, who's basically paid not only her own part of the support, but the support for the incarcerated person, is paying it all. They should be able to get reimbursed. And my experience is we have very good judges in Virginia, and I've had cases where people after incarceration get an award that's low, but they pay it back over time. And that should reimburse that parent. That parent's being denied and basically paying for and rewarding the incarcerated person, shifting the burden to the non-incarcerated parent. And that's not good policy for the child. So it does have a fiscal impact, mainly on low income, which is the real world. Now, you'll hear that we're only one of 9 states that have this policy, and I would respond by saying we're one of 9 that has it right. There's a survey that they refer to in the federal...
Wrap it up in the next 30 seconds.
Well, the survey's flawed. It doesn't have any Virginia things. There's a lot of fiscal impacts about moving inmates to the case. They say the UISA might apply. That does not apply because we're not going to have interstate issues. 16.1-276.3, talking about virtual, that's not mandatory. And they say that it affects 2,551 cases. Actually, this is a substantive change of the law. We have cases like Price, Marion, and Ostapan, which say that a substantive change is not retroactive. So it wouldn't apply to any case anyway until after July. But we have 2023 is the date that this has to be done, not 1 year from now, 2 years from now. We should be able to tell the feds to review it. It is it's been many years now since this came up, and I would like the DCSC to have the opportunity to work with the feds. It can be done. I was involved in a committee that actually reviewed the initial federal guidelines that led to our federal statutes almost 30 years ago. We met with Senator Bradley and the staff of the White House.
We need to get to the finish line here.
All right, I'm asking the court this committee to pass it by for 2 years so we can try to get this resolved. There's a lot of financial issues, and just pass it by. If we have to pass it by 2023, so be it, but let's give it a chance for the children of Virginia who are going to be suffering because of this. That's all, and that's not unfair.
All right, thank you. All right, we're getting some good comments here, good debate. Is there any other witnesses in the waiting room that have not yet testified?
There's looks to be one more, Mr. Chair. Alice Burlinson, if you want to go unmute and go ahead.
I'd start with saying whether or not.
Mr.
Thank you. Start by saying whether or not you support or oppose the bill, and then give us your reasons. You don't need to go through everything all over again. Thanks.
Okay, my name is Alice Burlinson. I'm counsel for the Division of Child Support Enforcement, and I support this bill clearly on behalf of my client. I also would just like to point out that this is not going to provide an automatic reduction for anyone who seeks a modification. It will give them the opportunity to go to court and ask for a reduction, which they do not have at this point in time. Thank you.
Great, thank you. Okay, we have the Survell amendment before us. Basically,
Mr. Chairman?
yes.
I had just emailed Senator Surville. I wasn't sure if the word alone that he added on line 43 also needed to be added on line 116 for an additional amendment.
I'm going to make the executive decision that you'd have to amend it in both places. So why don't we separate these amendments? The first amendment is whether or not to add the word alone after line 43 after incarceration, and line 116 after incarceration. We have a motion and we have a second. Okay, all in favor of that say aye. Aye. Any opposed?
No.
Okay, we've got one no. Louise. All right. So that amendment passes, adding the word alone. The rest of the language was a little bit verbose. Can the clerk re-report it? We don't have a copy. Kristen, can you?
Yes, Mr. Chairman, I can read it. On line 49, add, provided that nothing herein shall be deemed to prohibit a court from imputing income based upon a conviction without incarceration. Any other factor under this section or factors upon release, such as non-custodial parents' assets, residence, employment and earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the non-custodial parent, prevailing earnings level in the local community, and other relevant background factors in the case.
Okay. I don't think he left anything out. All right, we have a motion by Survell and a second by Edwards to adopt that amendment. All in favor say aye. And
No.
Survell says aye. Hold on. Noes? Who's no? I'm a no.
I'm a no.
And Obenshain's a no. What does that make us? Peterson is no.
And Lucas is no.
So what does that leave us? 3-3? All right, so the amendment fails 3-3. He can bring it up in full. Now we've got the bill before us as slightly amended by the word alone. Do I have a motion on the bill? Okay, I've got a motion to report. Do I have a second?
Second.
Okay, second from Louise. All in favor say aye.
Aye.
Aye. Obenshain says no. What's that make? 4-1, 5-1? All right, Delegate, so we're going to report your bill 5-1. We will not have debate in the full committee, although we'll not have outside witnesses. I think we are going to have some debate, though, so you may want to watch and just be available.
Thank you, Mr. Chair. I'll be there. Thank you.
Thank you, Delegate. All right. Next up, we have House Bill 2099, Delegate Coiner. Yep. Delegate Coiner?
Mr. Chair,
Yes, ma'am. Welcome.
I am waiting on two stakeholders to review some changes. Could you pass me by temporarily?
I will do whatever you want. Okay.
Thank you, Mr. Chair.
All right, let's go. Who do we have? Do we have any other delegates there?
9 o'clock was Wilson.
Delegate Leftwich,
Yes, sir.
you have House Bill 2190.
Since that's the time I'm used to going.
Okay. So, pardon me if I seem distracted, but I'm listening to your partner present a bill in general laws. And
You don't need to
right
listen
here.
to him. Okay. Just vote no.
Which two bills? Which one do you want to hear first?
How about 2190? Let's start with that.
Okay. So this is a pretty simple bill. It's been requested by the Virginia Trial Lawyers Association. And essentially what we're doing is we're taking the language of no surviving spouse, children of the deceased, or children of any deceased child of the deceased from line 14 and bringing it down and substituting that into line 18 after striking none. So it's really just a cleanup bill and makes the benefits of a lawful death action, the distribution of them a little bit clearer than what it is now.
Okay.
Mr. Chairman, there was a substitute that I had worked on with Mark Dix that I believe Delegate Leftwich was okay with. It's posted on LIS for your review.
Okay, well, hold on a second. So the whole purpose of this bill is to add more words where we have less words. It's not to change the substance.
That's correct.
Ugh. Okay, because we already define in subpart I, we define surviving spouse, children of the deceased, and children of any deceased child of the deceased. And then we say if there be none such, comma, then to the parents, brothers, and sisters. So what's wrong with the existing language?
Well, I can let Mark Dix is, I think, in the room. He might be able to provide a little bit more explanation. But from my understanding is just want clarity as to what none such means. There might be some circuit court judges around the state that might interpret that differently.
Mark Dix, you there?
Yeah, Mr. Chair, good morning. Mark Dix on behalf of the Virginia Trial Lawyers Association. So what happened is in 2019, as the committee is aware, we added certain parents to the Class 1 beneficiaries if they received certain support. The problem is that because in double little I, it said if there be none such, what were to happen if you had parents who received support, but there was no spouse or children, would the brothers and sisters in 2 get cut out? So we wanted to clarify that you can have a situation where there's no spouse, no children, parents, though, who do receive support, and you still get the brothers and sisters. Yep.
Okay, I got it. All right. Any questions from the subcommittee for either the delegate or to Mr. Dix?
Mr. Chair, I can't see the substitute yet.
Okay, I'm just looking at the hard copy here.
And Mr. Chairman, I just got back. Which bill are we on?
We're on House Bill 2190.
That would explain why Delegate Leftwich didn't vote on my bill a second ago.
Yep.
Retaliation.
He was telling what a lousy idea it was while you were away. Okay. All right. House Bill 2190 is the substitute up there, folks?
Mr. Chairman, it's posted, but I'm a little confused about the purpose of the bill because when I didn't think it was just to explain what none such was. I talked to Mr. Dix about it and he explained it so that the Class 1 beneficiaries who were the parents who were receiving support were only Class 1 beneficiaries if there was another Class 1 beneficiary. If there was no other Class 1 beneficiary, then they moved down to Class 2 so that they would be awarded at the same level as brothers and sisters and other relatives, which is why the substitute was necessary, because none such only included some of the Class 1 beneficiaries and not the parents.
Yeah, I take this to mean that the none such no longer applies because you actually have to delineate between the Class 1 beneficiaries and talk about spouse, children of the deceased, or grandchildren of the deceased. And then you flow downward to the next class of beneficiaries, which includes parents. Is that what you understand, Kristen?
That was my understanding too.
Okay, I think we're on the same page. Any questions from the panel? All right, any other supporters or opponents to this bill?
At this time, there are no hands raised to speak to the bill.
Okay, I'll entertain a motion. All right, I have a motion to report. Is there a second? Okay, motion to report and a second. All in favor? With the substitute, yes. With the substitute, all in favor say aye. Aye. Any opposed? All right, that one was easy. All right, what's the next one, Delegate?
So the next bill is House Bill 2193. And so what this bill attempts to do is create a situation where if you have a collection action in general district court, proceedings can be stayed if a settlement agreement has been entered into, and give the parties time to fulfill the terms of that agreement. And then once it has been fulfilled, the matter would then be dismissed from the docket with prejudice, or if one of the parties does not live up to the agreement, they could bring it back to court and essentially attempt to enforce the terms of the agreement. As I understand it, this practice is being used in Fairfax and has been fairly successful. And I think the benefits to this are to both the creditor and the debtor. For the creditor, it prevents them from, and the court, quite frankly, because it prevents multiple filings when people stop making payments. Likewise, a debtor would get the benefit of a creditor not entering a judgment for fear of having to file multiple actions. So they don't take a judgment and then have them fulfill the agreement. Whereas in this situation, they can withhold from taking a judgment on the prospect of the person completing the payment, which helps them, their credit ratings and everything else.
So basically, it allows them to avoid burning a non-suit if they reach a settlement agreement.
That too.
Okay.
Mr. Chairman.
Senator Obenchain.
Yeah. Hey, Jay, is there a time limit on this, the stay? I mean, could this go on for years?
That issue came up, and there is no time limit in the bill to directly answer the question. I believe that issue came up on the House side. I can't really remember. The Office of the Executive Secretary may have addressed that. I don't recall what the.
So, I think it's a good idea. And frankly, I've got a case in the Supreme Court right now in which we're asking the Supreme Court to sit on a dismissal, and I'm not sure that they are going to. But I can certainly see in Fairfax where without a statutory mandate, it can work because judges can exercise their discretion and say, look, it's gone on long enough. I mean, it's been pending for 10 years, and we've got to do something with it. So does this, and I don't know, does this give the court any discretion to do that, or can we give the court some discretion to dismiss it or to require some action at some point?
Is that a question for me or counsel?
That's a question for you. I was going to ask the same question because my concern is you could have 1 million cases pending in Fairfax County because nobody will ever dismiss a case. They'll all be left open. And look, I know as well as anybody, lots of times your paralegal gets that settlement check and goes in your trust account and people forget to file the dismissal. It's just, that's my biggest concern, that we're going to have a lot of open cases left in the clerk's office.
How about
We do have someone in the waiting room, Deanna Hackworth, who can address.
Can I just make a suggestion?
Yeah, Senator Obenshain and then Senator Serville. Senator Obenshain.
Would it work if you were to say, I saw the word shall in line 14, if you put may be stayed?
Mr. Chairman.
All right, well, that's pending. Senator Serville, go ahead.
Thank you, Mr. Chairman. And yeah, this is a common practice in Fairfax, and I thought it was a common practice everywhere. I was starting to wonder whether the delegate had problems with Judge Iaquinto.
Have we removed him from the bench yet? No,
not yet. But Mr. Chairman, at least the practice in Fairfax is that the matter is continued to a date certain for dismissal. It's not just stayed.
Right.
So, they put it out like 60 days or 90 days or something like that. And it seems to me that would probably solve the problem of cases just being left open and people forgetting to close them up.
All right. I have a thought, but do we have any other witnesses?
Yes, there is a witness.
Go ahead. Put them through.
Deanna Hackworth, please unmute and go ahead.
Good morning, Chairman Peterson and members of the committee. My name is Dina Hackworth, and I am here on behalf of the Virginia Creditors Bar Association, and we wholeheartedly support this bill. I did want to speak to a couple of the concerns that have been raised. In terms of a time limit, we did discuss a time limit and what that would look like. Unfortunately, the realization is that really only hurts the consumer. So for example, just to throw out some numbers, if someone owes a $2,000 debt and they can only pay $25 a month, that's going to take them 6 years and 7 months to pay off at $25 a month. And while the creditor may be happy to be patient and wait that time period, if the court imposes this case has to be resolved within 90 days, this case has to be resolved within a year or 3 years or 5 years, unfortunately, that is the time limit that would be imposed on the consumer. It's how much do you divided by a year.
Let me ask you this, Ms. Hackworth.
Yes.
Why is that the court's problem? I mean, why does the court clerk have to keep this file open for 10 years? I mean, the clerks get compensated based on how many cases they dispose of. And if none of these cases will ever be disposed, if every single lawsuit, 90% of which end up in a settlement, is going to end up with the case remaining open and everybody on a payment plan, and the clerks are going to be they're going to be jumping off the top of the courthouse because they're not going to have any cases actually resolved.
Well, I disagree with the premise that these cases are going to stay open forever. These, as the delegate mentioned, this is regularly done in Fairfax. Dismissals are filed all the time in these
cases. It's usually on 90 days. They'll usually give them 90 days to pay, and then it's set for dismissal. So it's typically 90 days.
Actually, that's not entirely the case. The court will accept a settlement agreement, and they will dispose of the case as other in the court system. There will not be another date set, and then it is incumbent on the plaintiff to file a dismissal when the terms of the settlement agreement has been met. So a lot of these cases are not continued to a date set certain.
Madam Chair. Hold on one second, Ms. Hackworth. Chairman Edwards.
Yeah, I have a suggestion on line 14. Rather than saying shall, say may with approval of the court. And the court has some kind of control over it. 90 days, 100 days, 2 years, whatever.
Okay.
May with approval of the court rather than shall.
That would be may, but that's kind of the case right now.
Well, I think the other question I had is this can be done anyway. They're doing it in Fairfax County. I guess it can be done anyway. But
this can definitely be done anyway.
Yeah, I don't know where else it's being done, frankly. But
I mean, Ms. Hackworth and I guess Delegate, this is where I am. I'm actually okay with this bill, and someone else had brought it to me, but there's got to be a time limit on it. I mean, 1 year to me would be at the outside of it. 180 days, frankly, would be. What's that? Okay, to a date certain. So why don't we'll do sort of a hybrid of the Edwards mode, so we maybe stayed to allow for full compliance with such, maybe stayed to a date certain.
I'll move that.
Okay. All right, I've got the Edwards motion, which I'm going to second, just saying the dismissal of such cases may be stayed to a date certain to allow for full compliance. All right, so we have a motion and a second.
Chair, may I address that amendment before y'all vote on it?
What's that?
May I address that amendment?
Yes, sir,
Proposed amendment
please.
before y'all vote on it? So I have a little bit of concern about the language of may. I think part of the problem we have here is that we have inconsistent practices throughout the state.
Right.
And you may even have inconsistent practices within a court, depending on which judge your matters before. And I think that's really one of the reasons why the bill was brought, was because some judges will do it and some won't. And if you make it permissive, then nothing's going to change. The date certain language, I think we if that's the will of the committee, we kind of have to live with. But I really have concerns about the permissive nature of the bill.
Well, I'll just tell you myself, Delegate, I'm not going to vote for it if it's open-ended. It's got to have some type of time parameters on it.
That I understand, I can live with. Really, I'm just pushing back if you respectfully on the permissive language of may, not instead of the shall. Or we could use the bill. That seems to be a popular.
We haven't voted on the amendment yet. So the thought was it may be stayed to a date certain, but the delegates' pushback is that the word may kind of obviates the need for the bill because we're trying to have a law here.
Mr. Chairman, I don't have any problem with a shall, given that it's a settlement agreement that the parties have entered in writing, saying that the court shall stay it, but insert to a date certain, in order to give the court some discretion as to what the end is. Now, I don't know that it ought to be, that date ought to be necessarily determined fully by the parties. I mean,
Right.
Court could agree,
Right.
but if the parties say stayed for 100 years, I think court ought to say, let's pick another date.
How about if we say the dismissal of such case shall be stayed to a date certain no longer than 1 year from the date of settlement? That way, at least we put some parameters on it. Again, my concern is we're just going to have cases that don't get resolved.
Could I ask a question
Yes,
of the
Mr. Chairman?
the patron or somebody? How long do you need to do it? I mean, nobody wants to keep it open for 10 years, I don't think, unless you're in Charles Dickens' Bleak House, where John Dice versus John Dice went on for several generations. But usually, what time frame are you looking at?
I would defer to Ms. Hackworth on that issue.
Thank you. And again, what I had mentioned is it really depends on what a consumer can afford. If it's going to take 6.5 years for someone to pay off a debt, again, I understand, Mr. Chairman, I understand your concern that that's an extended period of time. But I think one of the goals is to not have judgments entered against someone who's willing to pay. Now, if the committee wants to add in a check-in date that, once a year we come to court and say they're still paying, we want to keep going, that's fine. But if we're limiting a settlement agreement to a year period, then that's how long someone's going to get to pay off a debt. And that might still be more than they can reasonably afford. And that's not going to stop judgments being entered against people. And I think that's one of the points of the bill.
Here's my, Mr. Chairman.
Yeah, go ahead, Senator Obenchain.
Here's my suggested amendment: to a date certain to be established in the discretion of the court.
Here's my issue with that, and that is judges can leave cases open. Clerks cannot. I just feel like if we leave all these open-ended dates out there, I support the bill, but I cannot allow cases to just stay open for years and years and years.
I know.
We're not going to do that. I would say to a date certain within 1 year from the settlement.
Oh, okay.
Okay, can I?
Mr. Chairman,
Yes.
you could add language that said, which may be extended upon good cause shown by the court.
Okay, I don't,
Yeah, I agree with that.
all right.
Mr. Chairman, we do have another witness.
Okay, we have another witness. I feel like,
Brandy Singleton, please unmute and go ahead.
Mr. Chairman, members of the committee, this is Brandy Singleton with the Office of the Executive Secretary. We had actually worked with the creditors bar on this bill. And I just want to say three things. One, Senator Peterson, you recently said that the clerks get compensated on the basis of how many cases they dispose of. I don't know where that's coming from. That's simply not true. Second of all, in this arrangement that has been described, what this bill would allow for, the case is disposed of. It's given an other code. I think the courts would prefer not to have that date certain language, because what this bill does is it leaves it between the parties until or unless they come back to court. To put it as a date certain then means you're filling up dockets with hearing times that may not necessarily need to be had. So I think part of what may be infusing this discussion is that y'all are thinking of cases in circuit court, and I think that
I'm not thinking of the case in circuit court, but
okay.
Apparently you don't think I practice in general district court. I do. All right, I'm not quite sure where we're going with this, because
Mr. Chair,
I'm starting to lose enthusiasm for this whole bill at this point.
Mr. Chairman, is the executive
Chairman Edwards.
Is the executive secretary's office happy with the bill as is, or do you have any recommended changes?
We do not have any recommended changes. Actually, the proponents of the bill came to us pretty early on, and we worked with them on language, and we know that we can implement the bill as it sits before you now.
Mr. Chairman?
Senator Servell.
There has to be a date certain.
Yeah, I agree.
If we don't have a date certain, there's going to be some stupid collection docket with like 1,000 cases on it that ends and never ends and ends. And what drives cases to resolve is deadlines. So there has to be a date certain, whether it's 60 days, 90 days, a year. This bill has to have a date certain, or I can't support it either. So that's kind of where I am, Mr. Chairman.
Mr. Chairman, can I just ask a question?
Senator Boysko.
So
Please.
we understand that this already takes place in Fairfax County, correct?
Yes, ma'am. It's usually set for 90 days out.
So you have a date in. I'm just trying to understand from the patron why we need this bill if it's already allowed in Fairfax County. Clearly, Fairfax County doesn't have its own authority. Why are we considering, what's the reason that we need the bill statewide?
Mr. Chairman, it's because
Not everybody
Fairfax
is as
special.
proactive as Fairfax.
All right, let me just try and summarize. And I guess, from a practitioner's perspective and from someone who's in the court all the time, Senator Servell's correct. You need to have a date certain. You can't just have these cases open. And, it may look different from Richmond, but out in the hinterlands, we've got tens of thousands of these cases, collection cases going on. And hundreds of thousands. I'm only going to support this bill if it has a date certain for this type of agreement. And again, I support the bill, and I know people in the creditors bar, and it makes sense to me. You don't have to use a non-suit when you reach a settlement agreement. I was willing to do the case shall be stayed to a date certain no longer than 1 year from the date of settlement. I think that's reasonable. That gives people 12 months to pay it off. If they're on a payment plan, then they could always non-suit at that point, or enter a separate agreement, and then that makes a separate transaction. There's all sorts of things you can do.
Mr. Chairman, I like Kristen's suggestion of if you'd be able to come back for good cause shown to extend.
You do,
because that's the practicality. This is the practicality of how things work.
That'll never end. All right.
Mr. Chairman, the trouble with the memorandum is you've got another lawsuit. You don't want to do that.
Well, again, people have settlement agreements all the time without having the court having jurisdiction over it. The court's not a collection agency. All right, what do we want to do here, guys? We've been talking this bill for 20 minutes.
I move to report the bill as is.
All right, well, do we have a second on that? I don't hear a second. Do we have an alternative motion?
Yeah.
Mr. Chairman, I have a
Senator Serville.
on line 14 after stayed, I would put no longer than 12 months.
Okay.
To a date certain, no longer than 12
To a date certain, no longer than 12 months?
Yeah.
All right. I second that. All right, so we have let's do the amendment first. The amendment is on line 14, after the word stayed, put in to a date certain, no longer than 12 months. And then to allow for full compliance. All in favor of that amendment, say aye. Aye. Any opposed?
No.
We've got a no from Edwards and a no from Boysko, so that's 4-2. Okay, so the bill as amended is before us. Do I hear a motion on the amended
Move to
bill?
report.
Okay, I have a motion to report and a second. All in favor say aye. Aye. Any opposed? All right, so the bill as amended reports. And delegate, we may see you in conference, but that's where we are right now.
Thank the committee.
Thank you. Okay. I see Delegate Guzman and Delegate Coiner. Delegate Coiner, do you have the witness you were waiting on?
Yes, Mr. Chair.
All right, why don't we take you next? And Delegate Guzman, is your bill the same one we were talking about, the Bobby Hatton bill?
Bobby Hatton bill. No, that's a different one.
Oh. What's your bill number, Delegate Guzman?
I believe it's 2319.
Oh, 20, okay, all right.
And I have to chair a committee, subcommittee, Mr. Chairman, at 9.
Oh, you
if
have.
that could.
All right, well, why don't we take yours? Delegate Carter, do you mind waiting a few minutes?
Not at all, Mr. Chair.
Okay, Delegate Guzman.
Thank you, Delegate. Appreciate it.
Yep, go ahead, Delegate.
Thank you, Mr. Chairman, members of that committee. I'm bringing House Bill 2319, a bill that requires owners of firearms to safely store them out of the reach of household members who are prohibited from possessing a firearm. The bill imposes a $500 civil penalty if an individual fails to comply and the firearm is used by such an individual in a crime, unless it was used against the gun owner to protect themselves. We amended that last part to get on board with the Virginia Poverty Law Center. This House Bill 2319, Mr. Chairman, simply requires that gun owners keep their firearms safely stored when they are not physically carrying it or in control of the firearm. Unsafely stored firearms are a major public safety and public health issue in our country. This bill is about responsible gun ownership and keep their firearms away from individuals who have lost their rights to possess one. We have the opportunity to ensure that individuals who do not have a right to possess a firearm do not get the opportunity to through another family member or another member, of their household. This bill reduces the chances of those individuals committing further crimes or endangering those they love. The legislation is supported by the Coalition to Stop Gun Violence, the Virginia Center for Public Safety, the GIFORCE, the Moms Demand Action in Fauquier County and Rappahannock, as we had an incident in that area. And I hope it's the will of the committee to support this legislation. Thank you, Mr. Chairman.
Thank you. So this is a civil penalty of $500 to anyone that makes a firearm accessible to someone who's not allowed to have a firearm. Does that include, say, teenagers or children or?
Well, Mr. Chairman, the part that we are referring on the code is 18.2
right.
-08.2, which talks about felons.
Talks about?
It shall be unlawful for any person who has been convicted of a felony.
Oh, felonies.
Or any person educated.
All right, well,
felonies.
as you probably know, we're also discussing a bill about anyone convicted of a misdemeanor involving domestic assault, so I assume they'd also fall under this.
Yes, thank you, Mr. Chairman.
Okay, well, that's going to greatly expand the class of people. And was the answer yes or no to children? This does or does not include children?
I don't think so, Mr. Chairman.
All right, I see Lori shaking her head, so I'll take that as a no. Okay.
Mr. Chairman?
Yes, I'm going to question from or Senator Obenchain.
So, how would you interpret this language that says or has reason to believe? What constitutes reason to believe that somebody is prohibited? I mean, could a reasonable person be fined for this even though they don't know that person they're cohabiting lives with them, but there was a newspaper article a couple of years ago about them? I mean, how do you interpret that?
Mr. Chairman?
Yes, ma'am.
Is that question to me from Senator Ovenchain or to council? Just
No,
one.
it's a question to you.
Okay.
How do you
Okay.
interpret
Thank you,
that?
Mr. Chairman. Well, I would say, Mr. Chairman, that as individuals and residents of this Commonwealth, that we will take the precautionary measures, that if we're going to make the decision to live with someone, for the safety of our family, we will ensure that there is a criminal background check if you're going to be a stranger.
So
Or if
anyone you live with, they should do a criminal background check?
I would do it, and I think that everybody on their own safety have to do it if you're going to rent a space. And if you have children or you don't want to expose your family members, that's what I would do as a person.
I never made my wife do a criminal background check before I married her, and I should probably
Maybe you should.
Probably should have done that. All right. All right. I see we've got Lori and Andrew. I know you all are probably, well, I'm not going to presume anything. Andrew, why don't you tell us where you stand on this?
Thank you, Mr. Chairman, members of the subcommittee. We support the bill because this is a safe storage bill. It's not a Second Amendment right to provide access to a firearm to someone who's prohibited from having that access. So we would like people to keep their firearms about their person or under their control, or if they are not under their control, then they should be locked up so that that person who is not allowed to have it doesn't get access to it. Thank you.
Mr. Chairman.
Hold on yes, Mr. Chair.
This doesn't say anything about safe storage. I mean, that would be a separate bill to require people to keep their firearms in safe storage. I mean, that's not what the bill is.
Mr. Chairman, if I may.
Locked, unloaded, or disassembled.
Exactly.
Okay,
Lines 15.
All right. Lori, do you want to testify? Lori Haas.
Yes, thank you, Mr. Chairman and members of the committee. Lori Haas with the Coalition to Stop Gun Violence. We support the bill. The intent, part of the premise of the bill is to capture people, adult roommates. This is not intended for family situations. For parents know how to take care of themselves and their children and their firearms, and we respect that. This is intended to get at that. The reason to believe language, I believe, is in the code in other places. I believe that's why it was chosen. I recall some discussion in House Public Safety and working with the clerk in public safety to come up with that language. So if that doesn't pass the muster, for the legal definition of reason to believe, perhaps it could be fixed. But we support the bill. We appreciate the delegates bringing the bill forward, and thank you for your time.
Thank you, Lori. Okay. Anybody else on the proponent side? Patricia, you want to speak to the other side?
Thank you, Mr. Chair. VCDL is currently neutral on this bill with the, as amended, with the language that allows for the person to have the firearm in their possession or under their control. So it does allow for reasonable opportunity for self-defense. The language that was in question about reason to believe is in line with federal law also. We have no problem with that language. There may be instances where somebody that you met and have known all your life has a felony conviction that you didn't know about and had no way of knowing about unless they told you. Most people do not run a background check on their intimate partners. So Anyway, VCDL is neutral on this bill as it stands. Thank you for your time.
Okay. Anybody else have an opinion on the bill?
Mr. Chairman, can I move to report?
Did someone else have a? Oh, I'm sorry. Well, let's talk about it a little bit. I got to be honest, I'm not a fan of this bill because, again, you have all sorts of things in the house. You've got medication. You got all sorts of things that could potentially cause harm. Firearms obviously can cause harm. You know, when you enter in a relationship with somebody, you don't necessarily do a criminal background check on them. And even if you did, I mean, I think it's, you know, we spend all this time on criminal justice reform saying people deserve a second chance. And then basically, if you have a relationship with someone who has a prior criminal record, you're in violation of this law if you own a firearm. And I don't think that's fair. So I think this, I find this
Mr. Chairman, if I may, I could say that.
Yes, go ahead, Delegate.
Sorry, Mr. Chairman.
No,
I
go
just
ahead.
want to say that even with medication, we are already, as you probably know, I'm a social worker and I work at the CSB, and we are already have laws in place to put away a medication locked and away, and we even have events to destroy medication that could kill people in order to prevent lives. You know, and this is about, maybe I can share with you what happened. You know, there was an event, and I think losing one life is too many, Mr. Chairman. And what happened is there is an individual who was a former felon, didn't purchase the gun. His dad had a gun, and he took the gun from his dad while it was not secure and locked, and he went and killed a child.
Okay. And Delegate, I appreciate that. And passing this law isn't going to stop that from happening. I mean, people will still own firearms, and people that are felons or ex-felons or have a criminal record will come into their houses, and there may be their spouses, and it may be their sons. And again, being a felon in possession is a violation of federal law, and if someone enables that to happen, they can be an accomplice and in violation of federal law, and they can be prosecuted right now. But typically, the feds aren't going to prosecute unless there's an underlying crime. I mean, this is just saying that anybody at all that comes into your house and has a prior criminal record that would be disqualifying would make you liable. And it is a civil penalty, but to me, I find it overbroad, but I'm just one person.
Mr. Chairman?
Yes, Senator Boy Scout.
I believe this is a common sense, reasonable thing. It's basically saying people have to keep their firearms safe in the household. The VCDL is not even opposing it. I have never seen a time when I've seen a gun bill where they are not opposing it. I move that we report the bill.
Mr. Chairman, speaking, Mr. Chairman.
Yes.
Yeah, here's the problem with the bill. Mr. Chairman, the staff has provided me with Henderson versus the United States, a 2015 United States Supreme Court case, and that has to do with the court's authority over a convicted felon from disposing of a firearm. The courts have said, of course, they cannot dispose of a firearm to their spouse or best friend and still have control over the firearm. But the target is always with the convicted felon. This switches around to any person shall not allow a convicted person to possess a firearm, or shall not allow such person, meaning a convicted felon, to possess a firearm. This is people who are not convicted of anything. And to flip it around and say, well, now you have a duty to make sure you get $500 fine if somehow there's somebody that gets a hold of it. That's basically what it says. And I think that goes way beyond what we should be allowing the courts to do. If convicted felons cannot have firearms, the courts have authority to help to tell the convicted felon where to dispose of the firearm. And you can't dispose of it by giving it to your wife and still have control. That's what the Supreme Court has said. And to kind of go beyond that I mean, I think anybody in common sense would not let a convicted felon have a gun, and if they do that, then there's aiding and abetting. You could charge a person with aiding and abetting a convicted felon having a firearm. So I think the law takes care of itself. And I think this bill kind of goes way beyond what the law would allow.
All right, we have a motion for Senator Boysko. Did you have a second? Okay, we've got two. All right, all in favor of the motion say aye. Aye. Okay, all opposed nay?
No.
No. Is Norman here? Okay, so we got 3-3, so that will go to the full committee. All right, Delegate, thank you very much.
Thank you, Mr. Chairman.
Okay, last one is Delegate Coiner. Delegate Coiner, you still there?
Yes, thank you, Mr. Chair.
Yes, ma'am. Go ahead. Tell us about.
Thank you.
What's the number here?
2099, Mr.
Yes,
Chair.
ma'am. Yes,
You ready for me?
I am.
All right. Well, good morning. I am here to present House Bill 2099. It does two things. I would submit to you really probably three when you break it down. One, it results in a reduction in enforcement time for judgment liens to bring us more in line with best practices across the country. I'll go into details in that in just a moment. The second, it deals with the authority of settlement agents to release liens that have been paid but remain unreleased in the land records. So I'll start with the easiest of all of these. We have had similar about 12 years ago, legislation was passed that allowed settlement agents to release paid mortgage liens when notice is given to the mortgage lien holder that you've been paid out of settlement, you have X number of days to file a release, and if you fail to do so, the settlement agent has authority when that notice is given to do that release. This is, it did not cover judgment liens at that time, but what we find is that oftentimes judgments are paid at settlement and you don't find out that they have been unreleased until the next property owner is looking to resale that property and you're trying to track down creditors that have already been paid and have no incentive to give you a release. So our bill brings judgment creditors in line with mortgage creditors for post-settlement purposes. The second portion of the bill is really in two parts. One, when we look at judgment liens across the country, the vast majority of states give creditors, there's about 20 states that give creditors 8 years or less for total enforcement of judgment liens. There's 24 that give 10 years, and we are in less than a handful that give the benefit of 20 years to creditors without doing anything else and an additional 20 extension. So our bill in part one says going forward, all new judgment liens will have a valid 10 years. And rather than going to court, you can file a certificate and extend that for an additional 10. The second part of that enforcement judgment lien is, well, what do we do with existing judgment liens that are of record? And one of the reasons the main reason this came up as an issue is because we here in the Commonwealth have a lot of what I call deadbeat creditors. They come into the Commonwealth, they're here for a time being doing business. They take out warrants and debt, they get judgments against people, and they close up shop in the Commonwealth and disappear. Or liens go to record, they sit for so long that the creditors write them off. They bundle up those files, and then when you try to get a payoff, nobody can find the files to give you a valid payoff. And the only remedy for citizens today is to file a very expensive, hire an attorney, lengthy court process to deal with creditors who no longer exist and can't give them a payoff so that they can sell their property or move on with life. So we've reached a compromise that we believe is very fair to citizens as well as to creditors. Whereas anyone who has a lien that is of record as of July 1st gets the benefit of 13 years, which would leave it there, and then 2 10-year abilities to extend, not through a lengthy court process, but simply by filing a certificate to grant them 2 additional 10-year extensions. And we believe that that balances out the extremely cost prohibitive process that many of our citizens are going through. And the current practices in place really more directly impact our lower income citizens, because many of them with these warrants in debt end up with them against them because they didn't hire or couldn't afford to hire attorneys to deal with the issue. They get these judgments and they sit. So that is what the bill does. We are looking to balance many different public interest policies, and we believe we've done that with the bill before you.
Okay, thank you, Delegate. That was a very comprehensive explanation. I guess from my perspective, well, first of all, is any questions from the panel?
I have a question.
Chairman Edwards.
It seems to me what you're saying is the basic problem is you can't find the people to pay off, have the lien paid off after up to 20 years. You want to shorten it because you can't find the people to pay off the loan or to pay off the lien. Is that right?
Mr. Chair, what we have found is when you get past 10 years, yes, it becomes very difficult to locate many judgment lien creditors in the Commonwealth. And so if you look at other states and what they've done, a lot of them only give 5 years, and then you can renew for an additional period, or some only give the 10 and you can renew for 10 more. And this is why they do that. It really becomes difficult to track folks down. Many of these companies go out of business, or they sell their debt to another company, and yet they don't keep up with the files accurately. And so we do believe it's in the public's best interest, because the alternative today is a citizen files a court process, and when you can't find the creditor, they go through this whole process, and then the money gets paid in, and it sits at the state until someone either claims it or doesn't. And it's very, very difficult and expensive for citizens to go to for often very old, small dollar amount liens. And the cost to go through the court process is more expensive than the lien itself.
Madam Chair,
Chairman Edwards.
Wouldn't this so basically force lien holders to foreclose within 10 years? That'd be another possibility. I mean, that's how you pay off a lien. You foreclose and you sell the property.
You do have, Mr. Chair, you do have the right for that 10-year certificate, which brings you to the same 20 years today. The reason for that certificate is so that when you reach that 10-year mark, you are required by filing that certificate. It provides updated contact information for the lien holder, address, phone number, contact information, so that we know you're still out there and your lien gets the benefit of those additional 10 years. If you fail to file it, then your lien no longer is attached to that property. So we feel like it is a very fair way to continue the same amount of time, but to ensure that our creditors who are here and doing business are updating that information. And really, it's easier for them to get paid off. It is a real struggle to locate, based on the way liens are recorded in the Commonwealth, to locate folks for payoffs once it gets past the first few years of those liens.
Yeah, Mr. Chairman, my argument or suggestion is it would basically force lien holders to go ahead and foreclose within the 10-year period.
Right. They'd have to make sure they get paid.
Yeah, the alternative of keeping it for 10 to 20 years is one alternative is to foreclose within the 10-year period. So you got more foreclosures. What about that argument?
Mr. Chair.
Yeah, go ahead. Thank you, Delegate. Speak.
I would say, one, we have a bill that has come out this year that only allows that to take place for much dollar amounts. These are all smaller liens that we're talking about that wouldn't qualify for that. But that same process is a remedy today available to creditors when you look at what their ability is today. So we're not changing that remedy, and we're not shortening that time period. Simply stating that at that 10-year mark, you need to file a very simple certificate. That form is in the bill before you. It is a very simple form so that we all know who you are. The citizen knows how to get in touch with you to pay you off. Attorneys who are helping you know how to get in touch with you to pay you off. And your lien can still remain valid for the full 20 years if you file that certificate. So I would say we're not changing those remedies or forcing any faster foreclosure under these terms.
Yeah, Mr. Chairman,
Chairman Edwards.
Yeah, I'm looking at the alternative. The alternative is it kind of encourages lien holders to go ahead and foreclose rather than extend it. Just go ahead and foreclose.
Well, let me say, first of all, Delegate, I think this is great you're in this code section because I think debtor-creditor issues are not examined enough, and it does take up a lot of time and a lot of people's energy and heartache. And I think you do point out a great point that what if you're a debtor, you want to pay it off, you can't find the lien holder, you can't find the judgment holder. I've had clients in that situation. And you can pay it into the court, but you have to file a petition. You're definitely going to have to hire an attorney. I wish there was an easier way to do it. My problem is that you take a judgment and you only have 10 years to enforce it. That means you got to go to debtors' interrogatories. You got to bring them in. You got to do garnishments. You got to chase them all over creation. You can extend it, but anyways, Senator Servell.
You know, from my point of view, if your judgment hadn't been paid in 3, 4, 5 years, it probably ain't getting paid. I mean, I've had, you know, a few that pop up after a period of time when somebody finally gets around to selling a house and something gets paid. But I mean, the process to extend this beyond 10 years is just by filing a certificate. You don't have to, under this bill, I don't think you even have to go to court and file a motion to get extended like you do right now for the 20-year statute. So it looks to me like it's fairly simple to extend it if you really think there's the ability to do that. So it's not really clear to me. I mean, I think we're talking about a very small number of cases that are not collected within 10 years that actually might be collected in more than 10 years. And this, to me, sort of just clears out a lot of underbrush that really causes a lot of problems in the closing process. I mean, you know, I probably get 1 or 2 calls a year, you know, maybe every other year I'll get a call or something where some settlement agent will call up and say, hey, Servell, you didn't release some lien on a case. I mean, I can't imagine these closing companies are probably calling all the time on a daily basis trying to clear out liens on cases that haven't been from like prior purchasers or whatever else that show up in a title search. So to me, this just probably will save a lot of hours during the closing process for a lot of closing companies. So it seems to me a good idea.
Let me bring up another question, and that is, if someone already has a judgment, let's say they took a judgment last year or 5 years ago, would they not have a vested right in having a 20-year limitations period? I mean, can we just arbitrarily, I mean, because we're going to change the law, and years ago, Senator Edwards, you had that bill changing the law on deeds of trust, which, by the way, I lost that argument in circuit court, and I'm still upset about it. But the question would be, can we take away people's vested rights in these judgments? Yes.
I agree with you. There's a vested right in an expired statute of limitations. I'm not sure about shortening it, though. I've never actually researched that, although I think it's a good question. I'm not sure if Ms. Walsh.
I mean, can we tell somebody they're timed out?
Look at the enactment clause. It says it only applies to judgments recorded after July 1 of this year.
Delegate, did you want to speak to that?
Mr. Chair, I would love to speak to that. This is one of the issues we wanted to ensure that there was due process, and we wanted to ensure that folks, we did give the benefit for anything recorded prior to the benefit of 13 years and then 2 10-year extensions. So I would submit to you, existing lien holders today would only get the benefit of 20, and then they'd have to file motion and go to court and have an entire court proceeding to go beyond the 20 years. We're giving them 13 plus no court proceeding and the benefit of 2 additional 10-year extensions. So while it is shortening possibly the overall time by 7 years for some, that benefit of not going through a lengthy court process was a compromise to shorten that. But they do receive notice when you talk about due process and what their rights are. They do receive notice when this goes into effect July 1st. They can go ahead and start filing their certificates immediately. And that delayed enactment is what gives them the time to be put on notice that this has changed and their remedy to file a certificate.
Mr. Chairman.
And I'm sure Ms. Walsh can share with our work on that as well. She did helped with the research in doing it as well.
I think the issue is a vested right. You have a vested right now. It's taken away. That's the problem.
Yeah, I guess one question would be, Delegate, what happens if your judgment's older than 13 years old? I mean, you took a judgment, say, in 2006. Can you enforce it after January 1, 2022? You're timed out. It's more than 13 years.
No, no, Mr. Chair, you are not. And I'm happy for Ms. Walsh or others because we went round and round through this to speak to it as well.
Mr. Chairman, the way that we set up the delayed enactment clauses, the main provisions of the bill with the 10-year or the 13-year new limitations period wouldn't be effective until January 1. But we gave the remedy for any problems with infringing on somebody's vested rights to begin on July 1. So they have 6 whole months to file the certificate in court and get the 10-year extension. Okay, so there shouldn't be any kind of a limitation on their rights because we provided the remedy.
Okay, well, so I've got to go back and look at all my court, judgments I took between 2001 and 2011 and figure out which ones I've got to update, basically.
Mr. Chair, if I'm...
Or malpractice. Or Servel's coming after me for malpractice. All right, yes,
Mr.
Delegate.
Chair,
yes, ma'am.
if I may.
Sure.
We gave more time with our delayed enactment than this body gave for the mortgage deeds of trust, and we followed the exact same procedure that you all used at that point in time.
And you know what? I actually used that law to try and help a debtor get out of about a $2.5 million deed of trust. Unfortunately, a circuit court judge in Fairfax, who shall remain nameless, did not see the merits of my petition because I used this exact same argument. All right, Delegate,
but we do.
Yeah, go ahead.
But I know there are witnesses and folks who are here to testify. Okay. Try to balance out, the problems this is causing a lot of citizens in the Commonwealth with creditors' rights, and trying to deal with the existing liens. We use this body's past history in dealing with mortgage creditors to try to figure that out. So happy to continue.
Well, we have a lot of witnesses on this one, so why don't we go forward? Let's start with the proponents.
Those who wish to speak in favor of the bill, please use the Zoom feature raise hand to indicate that you'd like to speak in favor of it. Catherine Crawford, please go ahead.
Good morning, and thank you to the committee for allowing me to speak. I'm Catherine Crawford, and I'm speaking on behalf of the Virginia Land Title Association. We worked really hard with Delegate Coiner and other stakeholders on this bill, and we will recall that it did pass out of the House unanimously out of committee and out of the full House. And since then, we have had several meetings and correspondence with all of the stakeholders trying to come up with some good compromises. And this latest substitution, we have taken a lot of those thoughts and considerations and addressed those concerns. This is really trying to bring the Commonwealth in line with a lot of the other states, and also create reasonable expectations and a balance between the creditors' rights to pursue their debts that are owed to them and citizens of the Commonwealth who may not have been able to have access to legal services when these debts, when the warrants and debts were taken out against them. So the problem of what Delegate Coiner correctly coined the phrase of deadbeat creditors is a huge problem in the Commonwealth. And there are hundreds of thousands of dollars that are spent every year by settlement agents that they cannot pass that cost along to anyone to try and track down these creditors and get creditors paid. So we're really trying to strike a balance between the needs of the creditors and the needs of our citizens of the Commonwealth to be able to pay these debts and freely convey their property, refinance, try and get into better mortgages so that they don't lose their houses. So there are a lot of available remedies to the creditors under this compromise. And I would ask for the full committee to support this.
Thank you very much. Who's next on the proponents?
Matt Bruning, please go ahead.
Yes, good morning, Mr. Chairman, members of the subcommittee. Matt Bruning with the Virginia Bankers Association. We do support the bill and believe it will accomplish a more efficient process in addressing unresolved judgment liens when a homeowner sells their property. We appreciate Delegate Coiner and the other stakeholders' willingness to work through some of the issues. And I think we've got a process now, again, as the delegate mentioned, that mirrors what we did with the mortgage liens. That is, doesn't subject valid lien holders to a cumbersome process in updating those that information. So we support the bill. Thank you.
Aaron Barton, please go ahead.
Thank you, Mr. Chair, members of the committee. Erin Barton, I represent Virginia Realtors. We do support this bill for the reasons that Senator Sturvell mentioned. Some of these liens can really be a problem when you get to the closing table, but even more so when you're in a situation where you have homeowners who are trying to mitigate financial loss by doing short sales and trying to avoid foreclosure. You get people that get all the way to the closing table and find that they have, 10, 20 of these little liens on their property. They can't track down the lien holders to clear them. I was an agent in many of these cases where the property ended up getting foreclosed on because we could not in time clear the liens to successfully close the short sale transaction. So it is definitely an issue. We support the bill. Thank you.
Are there any others who wish to speak in favor of the bill? Chris McDonald, please go ahead.
Thank you, Mr. Chairman. Chris McDonald, Virginia Association of Counties. I just wanted to quickly thank the patron for her work on this bill. I know the version that passed the House did give some concerns to some of our county members, as well as those of our sister organization, VML. And I know that via the Treasurers Association, represented by Mr. Alan Albert, who is in the room as well, relayed these concerns to the delegate, who was very receptive and flexible in working out some new language that I believe is being considered this morning. So we just want to take a quick moment to express our gratitude to the patron as well as DLS staff for really working to address and allay our concerns. Thank you.
I have a question for the VACO representative. You still there?
Yes, sir.
I assume the tax liens are not included. They go on forever.
So I believe that was the intent of the bill, and I believe that the new language proposed this morning really clarifies that. I think Mr. Alan Albert, representing the Treasurers Association, can speak a little bit more eloquently to the substance of that.
So was that a yes or a no? Was that a yes?
I believe so, Mr. Chairman.
Okay. Alan, are you out there?
I am, Mr. Chairman. Thank you. And let me just echo what Chris said in terms of thanking Delegate Coiner and Kristen as well for burning the midnight oil to address some concerns we had. To answer your question, Mr. Chairman, the tax lien encumbers the property. So that would go on. This bill is about judgments. A judgment encumbers the property too, but they're two different things. Okay. They end you up in the same place, but they're two different ways to get there. We did have some concerns about the way this came out of the House, but the governmental liens remain at 20 years here. And I think the reason for dealing with them differently is pretty obvious. There's very little trouble finding the government. So if it's a local government obligation, you can generally know where they are, since most of them have been around since the 1700s or so. I'd be glad to answer any other questions.
Yeah, Mr. Chair.
Senator Edwards.
Alan, how you doing?
I'm good.
The question I'm concerned with is the vested rights. If you have a judgment lien now for 20 years and they want to shorten it to 13 years, isn't that a serious issue, a property rights issue, a vested rights issue?
It's not a concern for the treasurers, the VML and VACO.
I'm sure it's not.
Senator Edwards. It's an interesting question. I don't know that I'm really can shoot from the hip very well about it. I think it was Senator Sturvell that mentioned, there is good law out there about your vested interest in repose from a statute of limitations. Not so clear to me about judgments. I mean, you could certainly make the argument one way or the other, but I think as a practical matter, what Delegate Coiner has done is give anybody who is in that situation the means to extend it. So the right is not being taken; it's just being, I suppose you could say, it's being encumbered by one additional piece of paperwork that's a lot cheaper than the paperwork that you would go through now and have to hire an attorney for. I will just say, as the Realtors, the Land Titles Association and others have said, this is an enormous problem when you try to to close on sales of property, especially distressed situations like short sales. And, those properties tend to be leaned up. And I have a longtime partner who has bashed his head against the wall for years, trying to chase creditors like this.
Mr. Chair,
Senator Edwards.
I'm very sympathetic to the problem. My concern is the vested rights issues. I think it's a serious legal issue. If you want to go forward, fine, but to say I'm shortening the liens, judgment liens that now exist, I mean, yeah, you can say, well, you could do this, you could do that, but why should I do anything? I have a vested right. I shouldn't have to do anything. But so if you want to move forward, that'd be fine, but saying existing vested rights are going to be shortened, I have a problem with that.
All right, do we have any other witnesses to testify? I think we've gone through the proponents. I see Jay Spear with the hand up. Jay, I assume you're a proponent?
Yes, Mr. Chairman. Jay Spear with the Virginia Poverty Law Center, and we support the bill. The Poverty Law Center has been focusing on home ownership because it typically gives a great financial boost and lifts people out of poverty, as well as it helps close the racial wealth gap. So we think it's really important for these kinds of bills that address these issues because, frankly, judicial liens can be a real problem for homeowners and can lead to them losing their home. And so we support the bill.
Okay. Anybody else in support? How about the adverse side?
Baker McClanahan, please
Baker,
go ahead.
Hi, thank you, Chairman and committee members. My name is Baker McClanahan. I'm an attorney in Richmond. I have a collection practice statewide. I'm also a past president of the Virginia Creditors Bar Association, and I'm speaking on behalf of the Creditors Bar. We're opposed to this legislation or this bill. From past speakers, I understand I'm supposed to say adamantly opposed. First off, it's been 20 years in Virginia since, I believe, 1948. I'm not Professor Bryson and can't give you the exact history on it, but I believe since 1948. We are not out of step with other states. I think that there's some confusion about the judgment lien as against property and the enforcement of a judgment, which is a statute of limitations. This is reducing the enforcement of a judgment from 20 years to 10, and it's 20 years and it can be extended on a motion. We have extended judgments. We have many judgments between 13 and 20 years old that we are paid on. It's not unusual, and it very often does happen when there's a refinance or a sale. The issue for Land Title Association, I believe, is tracking down older judgment creditors on older judgments, but I don't think that the best way to do that is just to wipe out those judgments and toss them aside as being small judgments. There's no evidence of the size of the judgments that are going to be affected. There was an impact statement that was filed on the impact to the Commonwealth. I think that only caught a fraction of what the impact would be to the Commonwealth. I understand now from a change that they have been carved out of this. I also saw that there was a carve out for child arrearages, but what about judgments for intentional torts or judgments? I represent finance companies, service providers. I represent a group, self-insurance pool. So the judgments may be against people who borrowed money and didn't pay it back, who received services that they didn't pay for, or against people who caused damage that they didn't pay for. Do you know how many uninsured drivers are out there? Somebody ultimately has to bear that burden, and it ought to be the person that caused the damage and had an opportunity in court to say that whether they owed it or not, or whether they were liable or not. That has happened, and there's a reason that there's a longer enforcement period for judgments. These people are not willingly paying this. You have to track them down. You talk about judgment creditors being hard to locate. Judgment debtors, I assure you, can be much, much, much harder to locate. And judgment creditors, imagine 30 years ago or 40 years ago, how were judgment creditors located then? You had to go to the phone book or go to the library or check 411. Now we have more resources than ever to locate judgment creditors. If this is truly an issue of locating them, it sounds to me like it's with the information that is being provided when the lien is recorded. and that can be rectified elsewhere without gutting the limitations period for enforcing the judgment.
Okay.
However, as much as I dislike reducing it from 20 to 10, my biggest problem, our biggest problem, is the retroactivity. It seems like this 13 years to to decide on which judgments ought to live and which ones ought to die is arbitrary. There are many judgments between 13 and 20 years old that pay. I spoke to one lawyer in our association who, until recently, was a sole practitioner. And just in 2020 alone, he had over $500,000 in collections for his clients on judgments that were between 30 and 20 years old. If the retroactivity stays and there's this staggered approach where he'll have a window to file to save those judgments in that period. Again, a very small firm, I think it's maybe 2 lawyers now, he would be looking at, he practices in Tidewater, and he would be looking at filing over 2,000 extension certificates in a 6-month period in Chesapeake Circuit Court alone. Almost 4,000 in Norfolk and 7,400 in Virginia Beach. Are the clerks even able to move that much paper in such a short period of time? We already know from other bills and from stories in Lawyers Weekly about how understaffed the clerks are. That would be a significant problem. We also are concerned about not being able to extend these beyond one more time. You obtain a judgment. If I obtain a judgment now, it'll be 10 years. If I wait until the 9th year, I can extend it 10 more years. So I will have 19 years, and that'll be it under the statute as it's written now for a new judgment. I see Delegate Coiner shaking her head, but for a new judgment, you only get to extend it one time under the way that it's written now. The extra extension comes for these other judgments. We also don't know what the cost is going to be. Will there be no cost? As you know, if I send in a judgment release, when there's no cost for a judgment release, will there be no cost for a certificate? Will it cost $10, which is the cost for docketing a domestic judgment? You know, there are a lot of moving parts to this. And you know, you've already gotten special interests that are carving out the things that they don't want to be affected by it, which would include apparently the Commonwealth or the local governments. But I mean, what about a judgment for an intentional tort? Should that be pulled out? It just seems that there is a better way to address the problem that's been identified, which is tracking down creditors, and there's a different place in the code for it. You can refer to the statute that talks about when a judgment is a lien against real property. Perhaps there you could require the judgment creditors, in order for their judgment, not affecting the enforceability of it, but in order for their judgment to actually constitute a lien, that they would have to provide certain information over a certain period of time. And there is also a code provision that deals with judgment creditors that cannot be found. For all of these reasons, the fact that we can't do the extension more than once, the fact that it's retroactive, the fact that we have no idea what the cost is going to be or the impact on our clerks, we're opposed.
All right. Thank you, Baker. Anybody else opposed? And then, Delegate, I'm going to give you a chance to rebut.
Matthew Tiffany, please unmute and go ahead.
Mr. Chairman, members of the subcommittee, Matthew Tiffany from Tiffany and Brown on behalf of the Virginia Creditors Bar Association. I too would like to thank Delegate Conyer for her efforts in working with us to try to get this bill in a palatable position. Mr. McClanahan did an excellent job in putting forth the points that I would make, so I would just gloss over them very quickly. As Senator Edwards has stated, this bill would strip away a legal right that's already afforded to those judgment creditors who, in the past, for a set filing fee, were by statute given a set amount of time to collect their judgments. Now, and we do assume there will be a fee with the certificate, they will not only have to expend time but money to get what they've already been given by that statute. Businesses are failing throughout the country. We're in a pandemic, and now we're being asked to go to our clients and ask them for additional funds and time to get what they already have. We do not think that that's proper. And then as far as the bill itself, if we are to file these certificates, it will absolutely overwhelm our already struggling clerk's offices. I have spoken to one clerk, superintendent in the D department of one local court, and she said, based on just my volume, and I am that sole practitioner for the last 14 of 16 years, she said just on my volume alone, that would overwhelm her. So we believe that this is something that the retroactiveness of the bill, at the very least, has to be carved out, and that the judgments that we already have in place should stay. Thank you.
All righty. Delegate, why don't you, I'm going to give you a minute to rebut, and then I've got a couple thoughts, and I know other people on the panel have thoughts. So, Delegate, go ahead.
Thank you, Mr. Chair. There's been a lot of talk about the retroactive and liens that would be wiped out from 13 years to the current 20, and no lien is being wiped out. We are simply stating that you have to file a certificate, a single piece of paper for that to remain valid. And just in hearing the arguments about whether or not you're imposing on creditors existing rights, this body, we change laws all the time in the best interest of the public to protect them. I mean, we just went through a whole lot of changes to landlord rights in terms of making them take payment plans, making them change things within their leases, because we as a body believed it was in the public's interest. So I get it. The creditors do not like that something that they've had the benefit of historically in Virginia is being changed. But, we will go through another big recession. And the reason we dealt with the mortgage rights back in 08 and 09 was because people were being foreclosed on and short sales could not happen because they couldn't get rid of credit line deeds of trust because so many of those fly-by-night mortgage creditors disappeared. And the same thing is going to happen, and we will have homeowners who are trying to track down all of these little judgment lien creditors to get payoffs. We are giving them the benefit to keep their full 20 years. We're just asking that you file a certificate so that we know who you are, we know how to locate you, and that debtors have the ability to quickly get payoffs to free up their property for sale. And, I would say we've done everything we can with the substitute before you this morning to ensure we can locate creditors in the retroactive portion of this bill.
Mr. Chair?
Senator Boysko.
Could I ask a clarifying question to the patron?
Yeah, please, go ahead.
So from what I understand, you just stated that the creditors are not being relieved, like they're not going to miss their money. This is giving some relief, but it's not completely excusing the existing debt. Is that correct?
Yes, Mr. Chair, I would submit, and I've said this to the creditors, I believe you're going to get paid faster under this process for older liens because it is very difficult to locate creditors based on what gets recorded in the land records today. So again, you file that certificate, your 20 years is preserved. We're not decreasing it. I agree there is an extra step we're asking you to take for existing liens today. Completely agree with it. But I do think it's in the public interest that debtors have accurate information about who has liens against them and how to pay those off quickly without going through a court process.
Okay. All right. I've got a couple thoughts on this. And first of all, this has been a very helpful discussion, and this is an excellent piece of legislation. Not that I agree with it all entirely, but I think, again, it opens up a code section, and it really would have a macro effect on a lot of people, both positively and negatively. And the one thing that I find a little bit sort of off-center to me is that there's this talk about creditors as if they're sort of typically institutional people like credit cards, hospitals, and I know mostly they are, but I've represented clients that got judgments because they were swindled, because they were embezzled from, because people did bad things to them or breached contract, and they took a judgment, and they've had a judgment. There's a guy named Brett Amendola who lives in Leesburg, or used to, who swindled an elderly couple of mine, or elderly clients of mine, out of $750,000. I took that judgment in 2008. That would be timed out. He's my age, so he's probably out making money again. So There's a lot of people that get a windfall from this that don't deserve it, do not deserve it. Now, can we go and file a certificate for against all those people? Yeah, I'm sure we can. But I'm not always sympathetic to debtors as a class of people just automatically. And it's interesting you bring up the landlord-tenant. I'm not a big fan of some of those bills because they do vary people's rights, and it does have an impact on sometimes people that are landlords that aren't able to protect themselves. Not everybody's an institutional player in this business. So,
Mr. Chairman, will you yield?
I will yield in a moment. So I'm not a fan of the retroactivity either. I like the concept of the bill, but I would probably like to see us pull out the retroactive portion. Yes, Senator Servo.
I just wanted to know if you were wearing Mr. Amendola's suit today.
Well, that is true. In debtors' interrogatories, I wasn't able to collect the money, but I did collect his suits because we were both size 40, so I do occasionally wear them. That is unfortunately a true story. All right. Any other senators? This is, like I said, a topic for a lot of discussion. Senator Edwards, did you have some comments?
Well, I agree. I mean, my concern is retroactivity. I think it violates property rights. I mean, it violates due process. You can't just say you have a 20-year judgment, but I'm going to make it 13 years now. Now, sure, the judgment creditor can extend it, but that makes they have to do something, and I don't think anybody should be required to do this. So that's my concern.
All right. Anybody else? Obenshain, Boysko, you've spoken. All right. What I would suggest an amendment that would pull out the retroactivity, which I think would be accomplished by stripping lines 49 through 51.
Mr. Chairman.
Yes, Delegate.
You could take out lines 49 through 51, but I believe you would also have to add in on line 12 after judgment dated on or after July 1, 2021, so that 10-year period is only for liens going forward.
Okay, I will move that amendment, Kristen, that basically this will be prospective. In other words, we're not going to take away anybody's retroactive vested rights. That's my motion. Is there a second? All right, I've got a second from Obenshain. So, Kristen, basically we'd be pulling out lines 49 through 51 and then adding the additional language on, you said it was line 12? Kristen?
Excuse me, I'm sorry, on line 12. And then I would probably add an additional sentence in A to specify that liens dated prior to July 1 are still under the 20-year period.
All right. I think you can craft that language for the full committee. So that's a motion. I have a second. All in favor say aye. Aye. Any opposed? Okay, so we have basically pulled out the retroactivity. Do I have a motion on the bill as amended? Okay, we're going to recommend reporting. I've got a second. All in favor say aye. Aye. Any opposed? Who has? Okay. All right, so Delegate, I think we've made some surgery to your bill. It may go to conference. I think if so, we'll have to talk through this. But again, I think this is a very educational discussion. Thank you for bringing this bill to us.
Thank you, Mr. Chair.
Okay. Is that everything? All right. Subcommittee is adjourned.